Yes, please.
Item number 1 for pronouncement of judgment.
On the basis of the law which I have discussed, the respondent became entitled to return of the seized goods on 4th October 2023. The appellant authorities did not release the goods. Now, if as a subsequent event a confiscation order was passed, that order would operate on the goods wherever they were situated. This subsequent confiscation order has nothing to do with the cause of action involved in the writ petition and appeal. It is an independent right acquired by the appellant authorities to be exercised independently. So, in my opinion, the appellants are obliged to immediately return the goods to the respondent subject to the confiscation order. In other words, even if it is assumed that by virtue of confiscation, the ownership of the goods has been transferred to the appellants, still its possession status quo ante, which was to be with the respondent, has to be restored until the confiscation order is enforced. We dispose of this appeal by affirming the judgment and order of the learned single judge made on 5th April 2024. We direct the appellants to return the seized goods to the respondent within 4 weeks of communication of this order. We also make it clear that on the subsequent events, the appellants are free to take such steps with regard to the goods as they may be advised. All interim orders are superseded by this final judgment and order. MCWF 14 of 24 is also disposed of by this judgment and order.
Item number 2.
Yes, please.
Lordship, before my learned senior starts the hearing of the appeal, if Lordships are pleased to look at the order passed on 27th November. 27th November. Lordships have it. Lordships are pleased to see page 2 of the said order, Lordship. The appellant shall open a bank account in its name and make a short-term deposit earning the highest rate of interest of the monetary benefits which would be payable to the respondent as of today in terms of the impugned judgment and order. If any monetary benefit is to be paid to the respondent subsequently, then from now onwards the sum which becomes payable monthly or otherwise shall be deposited in a savings account in the name of the appellant. If and when the amount crosses 2 lakh, it is to be invested in a term deposit on the same terms and conditions as the initial term deposit. A statement of account should be furnished by the appellant to the respondent. The appellant will continue to furnish quarterly statement of account to the respondent if the appeal is
Yes,
not
we have read it.
So we have not, I'm for the respondent. No such account or anything has been furnished.
madam.
Till date.
What about the
Lordship.
compliance with this order?
Lordship, we have complied with the order, Lordship, but as has been read just now, Lordship, a quarterly statement of account. It's yet to
Because unless it is furnished, how will they know that you
Lordship.
have complied with the order?
Lordship.
This is regarding pension.
But we have complied with the directions of this honorable court, my lord.
My pension has been kept in abeyance.
All right, we can start hearing the appeal. They will file a report and furnish a copy to you showing compliance with the order.
Lordship.
You are ready to proceed today.
Hello?
You are ready to proceed today.
Lordship, we are ready, Lordship. May it please your Lordship?
1 minute.
Just
we will- all hearing matters today.
Lordship.
Make a first call. Pass over.
Lordship.
Call item number 3.
Item number 3.
What is the mistake?
You are ready to proceed with the appeal?
Well, actually, what happened, my lord, by last order also, we directed to file as informal paper book. Well, we have prepared, well, there is some problem with the pagination, my lord. But otherwise, the papers are there in the memorandum of appeal also, my lord. If I may refer to that,
But the direction is there. You have to file the paper book and give them a copy.
my lord. Kindly grant me 1 week's time, my lord. I'll try to give it by tomorrow, my lord.
It's ready.
Is ready now.
Yes, sir. We have served them. We can.
Learned Deputy Solicitor General submits in court that the appellants are in the process of preparing the paper book. Full stop. He needs a week's time to file it. Stop. The time to file the informal paper book in terms of the order dated 31st January 2025 is extended till 25th February, by which date a copy thereof should positively be served on the advocate on record for the respondent. List this appeal for hearing on 10th March.
Well,
Mobilize.
the-
Item number 4.
Lordship, a small accommodation, Lordship, in this matter.
Sorry?
I need one accommodation, Lordship, in this matter.
You're for the appellant.
I am for the appellant, Lordship.
Further adjournment.
Lordship, here I'm just seeking for one judgment, Lordship. I was searching for that judgment, Lordship, and for that for that purpose only, Lordship. Lordship, actually, Lordship, this is a petition under the Statutory Act, Lordship, EPF, under 7I, Lordship, and any judgments if I get under 7I of the appeal, Lordship, for which I am searching, Lordship.
My lord was presiding over the bench when this appeal was admitted on 4th September. The paper book is not necessary.
Lordship, no, paper book. I have enclosed everything, Lordship, as an annexures, Lordship,
In the memo appeal.
in the memo of appeal, Lordship.
Yes, what do you say?
Oh, my lord, I was otherwise ready, but if my friend has some difficulty, my lord, I will not.
When you please agree on a date.
I'm always available, my lord, subject to her convenience.
Lordship, except Wednesday, any date, Lordship, except Wednesday.
$24th?
Lordship, if 24th can be avoided, my lord, slight difficulty on that date. Any other date.
25th?
Lordship.
By consent of learned counsel for the parties, this appeal is adjourned till 25th February 2025. Come out to be heard. In the papers enclosed with the memorandum of appeal.
Lordship.
Obliged.
Yes, further
Right.
fast over.
Second call, item number 2.
Please show us the impugned judgment.
My lord, impugned judgment is at page of the paper book, my lord. It is at page 100, page 100, my lord.
Lordship,
You were not regularized. You resigned.
no, Lordship, what happened here?
No, please listen to this quote. You resigned.
Lordship,
Now, it was something absolutely hopeless calculation. You resigned, thereafter your regularization came. Regularization,
post facto.
post facto, you would have been regularized.
Lordship,
Right? You would have been regularized. Had you been regularized, then only you could have availed of voluntary retirement. In the service you were, when you resigned, there was no VRS. Could you have availed of VRS?
Lordship, what happened here?
No, please answer the question. What happened? You leave.
If I was not regularized, I could not have availed VRS, Lordship. But here what has happened is I was regularized way back in 1998. When I filed after serving for around 25 years, when I was otherwise eligible
You thought you were regularized.
No, letter was issued by the government, Lordship.
You were regularized.
Others
No,
similar,
Lordship, by an incompetent authority, my lord.
that is the plea that they came up when I filed this writ petition. That earlier regularization by which 5 people were regularized apart from me. 4 others have been regularized, getting pension, everything, Lordship. There is no dispute. I have been picked out saying that regularization is incompetent. When I have applied for VRS, Lordship. Now, all throughout my 30 years of service, they never said that I am an ad hoc employee. After my regularization, initially, I was transferred. Subsequently, entire benefits was given to me. I have always been treated as a regular employee, receiving all benefits as a
Where are
regular.
the documents?
Lordship. If Lordship is pleased to come to page 34 of the memo of the paper book. '34 is the order in original. Page 35, Lordships may have. Page 35. Lordship, this is an order of 21st July 1989. By which I was appointed on an ad hoc basis as an assistant teacher along with 3 others. My name figures at serial number 2, Lordship. Srimati Uttara D. Sangma. This was my order of initial appointment issued by the Inspector of Schools in the sanctioned post.
Ad hoc basis.
Lordship. Now thereafter, this is my appointment order. Thereafter, Lordship is pleased to come to page 38. 38. Page 38 is the type copy. Page 38, Lordship, subject regulation of service order, dated 1st September 98. On the approval of the Additional Director of Public Instruction, Meghalaya, White so-and-so, following teachers in grade A are regularized with effect from 28/10/96. My name is at serial number 2, Lordship. So from 1998 till the time I submitted my VRS in September 2023, I was under the impression, Lordship, that I was regularized by the concerned authority. And if I may also point out, that has been also recorded by the learned single judge, that the other persons mentioned in this order have been regularized receiving their benefits, Lordship. It was only now that they came and said that this order of 1998 was by a incompetent authority, Lordship. But they have not also mentioned who was the competent authority otherwise.
That you can't say, madam.
My lord, it has. It's quite surprising that at the appeal stage, they're saying they were unaware till 30 years later.
So you,
that
you press your appeal. Please sit down.
Lordship. My lord, in the instant matter, Lordship, so the respondents,
Because when somebody,
Lordship,
a private citizen, receives a letter from the government,
my lord,
it is presumed to be legitimately, legally issued. He is not going to verify that whether that officer is authorized, whether the seal is genuine, etc. It is presumed to be regular unless you say that it is a fake fabricated document.
My lord, that presumption did not last for 30 years, lordship. If you, I may take this honorable court to page 105, my lord, of the impugned judgment. (104), my lord, it's the paragraph 5, 104, lordship, if I may read. Having heard the learned counsel for the parties, it is seen that in her service, the petitioner had been caught in an unfortunate situation, inasmuch as after serving for 33 years and aspiring for a career in politics, has instead been compelled to approach this court to fight for her pensionary and other benefits. The fact that the petitioner had been serving on being appointed since 23/7/89 is not in dispute, as also the fact that the letter dated 1998, the inspector of schools had regularized her services with effect from 29/10/96, though the same at a much later stage was not accepted by the respondents on the ground that the same had been done by an incompetent authority. However, it is seen from the materials on record that ex post facto approval for the petitioner's regularization had been sought, meaning thereby the matter was under active consideration. This is evidence from the letters dated, my lord, 15/5/2017, 29/6/2017, 10/8/2021, and 4/10/2021. Other letters present in the records also show that on 20th/9/2021 and 10/2/2022 that the process of regularization was still on. My lord, the claim that they were not aware until after 30 years later is false, lordship. They were very much aware that regularization of the respondent was under active consideration by the authorities, my lord. So they cannot take the plea as a last resort to gain compassion from this honorable court on the plea that they have served. Lordship, we understand, lordship, that she has served for 30 years, more than 30 years. But lordship, what happens over here is that she resigned, lordship, before confirmation of her regularization, before she was regularized. That was the only difference. Had she not regularized, lordship, because the confirmation came a good 2 months after she had resigned, we wouldn't be standing here today, my lord. But because of the respondents' decision to participate in politics, she had undertaken the decision to resign, lordship. There was no pressure from the government for her to resign. Because she had approached this honorable court at the first round of litigation for disposing of an application filed by her. After examination of the same, my lord, the government authorities had let it be known that she cannot take up VRS because her service had not been regularized. And this was very much within the knowledge of the respondent, as has been explicitly mentioned by the single judge at page 105, my lord. They cannot say they were not aware until the end of her service, not even her service, towards the end of her resignation, my lord. Lordship, we understand that she served the state for more than 30 years, but the law is the law, my lord. If we are going to open this door for one person, other doors will open for other people also, lordship.
When did she resign?
Lordship, the letter for resignation had come in the month of March, lordship, and the same was approved accordingly because she had to contest for the election because she had to file a nomination, lordship.
No, what is the date?
2nd March.
2nd of March.
2023.
The resignation is
Accepted?
On the same date.
Lordship, the resignation letter is
sent on
dated 1st February, and the same was accepted by the government on 1st February itself, lordship. This is
1st February.
Lordship, this is at page 126, my lord, of the memo of appeal.
I'm sorry, 1st February. I stand corrected, Lordship. I apologize. 1st February, and acceptance on 2nd February, with effect from 1st February.
Lordship, the letter from the petitioners at page 125, my lord. if I may read, Lordship. To the Director, School of Education and Literacy, Meghalaya, dated 1st February 2023. Subject, submission of resignation letter of service from the post of LSEO, Tura, due to non-acceptance of my application for VRS on September 2023. With the above aforementioned subject and reference letter for VRS from under Fundamental Rule 56C, which has not been accepted by the government for their known reason, may I therefore furnish a few points in response to non-acceptance of voluntary retirement. That, sir, the option of voluntary retirement in exercise by the employee with 3 months' notice on September 2022 under Rule FR 56C on condition that she has attained the age of 50 years and above and in continuous service for more than 25 years. That, sir, as per rule, the concerned department do not comply by giving notice /reply to the concerned employee within 3 months and hence fulfilling the instant case. The appellant must be held to have lawfully retired as notified by her as per the rule 56C serial number 27. In view of the concerned department failure to recognize the departmental regularization and playing the game of deferring the acceptance of VRS time and again, I hereby tender my resignation from the government service from the post of LSEO Tura with immediate effect. And this was accepted on the same day, Lordship.
Where is Rule 56?
Lordship, at page 128, my lord, Annexure N, we have the Meghalaya Civil Service Pension Rules 1983.
Rule 56, Lordship, has been quoted by the learned single judge.
Page 128.
Lordship, 128 is Meghalaya Civil Service Pension Rules, my lord, 1983. At Rule 23, my lord, Sub-Rule 1. This is with regard to regularized employees, my lord. For feature of service
56.
my lord. 56, Lordship. I apologize, Lordship. I don't have it in hand right now.
No, it is for Fundamental Rule 56C. It is not this one.
The rule which is otherwise applicable is at page 107 as
No,
quoted by
this
the-
letter quotes
56, I
56C.
understand.
What is this?
56C, Lordship, would provide for employees can retire voluntarily if they meet the conditions of FR 56C. But, Lordship, this is with regard to voluntary retirement of a regularized employee, Lordship. Over here,
And if it is not accepted, then regular retirement.
Lordship, the government's consent is not required for the retirement to be legal, Lordship, with regard to 56C. But here, Lordship, 56C talks about a regularized employee, Lordship. Our stand is that the respondent was not regularized at that point of time.
Regularized on
It was in the month of April, Lordship, 2023. 25th of April, 2023, Lordship. At 131 of the appeal memo of appeal, Lordship.
And she resigned on 1st
February 2023, Lordship.
Where is the regularization document? 25th April.
Lordship, it is at the paper book, my lord, at page 131.
One
131, my lord.
I'm at number 1, Lordship.
Where is the appellant's respondent's name?
Serial number 1, Lordship.
Serial number 1, Lordship.
Uttura G. Sangma, assistant teacher, 0109, 1998.
How many years of service was left?
33,
If she had not resigned,
Lordship.
how old was she?
Kindly get a minute. She was 54 at the time of submitting resignation. 54. Another 2 years.
Another 4 years,
4
Lordship.
years, 60. Go. She was 54 at the time of resignation.
4 years left of service.
Lordship.
All right.
Lordship. My lord, the state is aggrieved by the order passed by the learned single bench, my lord,
Yes.
to the effect that the respondent is not entitled to any benefits, my lord, pensionary or otherwise, because the stand taken by the respondent was resignation, my lord. No other. There was no other stance, and with that, lordship, I beg to rely on the Meghalaya Civil Service Pension Rules 1983, lordship, which at Rule 23(1), lordship, very explicitly states that resignation from a service or post, unless it is to be withdrawn in the public interest by the appointing authority, entails forfeiture of past service, Lordship. Lordship, we are aggrieved that benefits have been conferred on her Lordship by the single bench, despite her not being a regularized employee of the government, Lordship. And the fact that she is not entitled, my Lord, because the Supreme Court recently, not recently, my Lord, at some point of time had decided with regard to pensionary benefits, Lordship, with regard to the distinction between voluntary retirement and resignation, my Lord, I beg to rely on 2020 Volume 3 SEC 346, Lordship.
There is no voluntary retirement of an ad hoc employee.
No, my Lord, not at all.
So, how is this case relevant?
Lordship,
A resignation and voluntary retirement?
yes, Lordship.
Even if it is taken as voluntary retirement
Lordship,
and the employment is ad hoc,
yes.
no benefit.
No benefit should be conferred, my Lord. Lordship, we also beg to state that, as I had been mentioned in the judgment of the single bench, Lordship, since the year 2017, there has been active participation from the government side to regularize the services of the respondent, Lordship. But we could not see that. We could see that our endeavors were rejected, Lordship. We don't know why, because she, being under the presumption that she was regularized, maybe, Lordship, but she had such endeavors were rejected by the respondent, Lordship, to the point that
Now, had she not resigned,
Lordship,
she would have been disabled from participating in the election, contesting the
Lordship,
election.
she would have been, Lordship.
She has contested the election.
She contested, she lost the election, Lordship.
If I may only make one submission, Lordship.
No, let her finish, then you will.
Please.
So, my Lord, but that is a personal stance, Lordship. It has nothing to do with her service, because that is a personal decision. She was fully aware of 2017, 18, 20, 21 efforts made by the government. But she decided to take the personal decision into first applying for VRS, despite being aware that she was not competent or regularized. And then after the same was denied, then she had resigned, Lordship. So, Lordship, she does not qualify for pensionary benefits under the Meghalaya Civil Service Pension Rules of 1983, Lordship.
You see, she decided to contest the election.
Lordship.
Now, if you contest the election, you cannot hold a public post.
My Lord.
All right.
Lordship.
So there are two things.
Lordship.
Either or. Either she knew that she was ad hoc. All right.
Lordship.
And her regularization was under consideration.
My Lord.
Now she had two options, either to give up the election and keep working so that the regularization came through, or throw up the employment.
Lordship.
So let us for the first assume that she knew everything, but she chose the former, that I will throw up the employment, resign. I don't want regularization.
Lordship.
So I will contest the election.
Lordship.
All right.
Lordship.
Now, number one. Number two option is that she had the belief that she was a permanent employee, regularized from 1996.
Lordship.
And that to contest the election, she had to resign.
Lordship.
Now, if she resigned, being a regularized employee, she would have at least be entitled to the voluntary retirement benefit of a permanent employee. So she gave it up. Now, these are all questions of fact.
Lordship.
Now, then the regularization came
Lordship.
on 4th April. Now, the regularization document, now the government is supposed to be aware of who's on the rolls and who's not on the rolls of the government as an employee. Now, if a person has resigned, it would immediately be struck out from the domain of consideration.
Lordship.
Now, a person who has resigned means that there is severance of relationship of employer and employee. He is no longer there. Yet they have put her name as number one regularized employee.
Lordship.
That needs an explanation.
Lordship,
And now if that is the case, she has lost the election. Now if she had won the election and the regularization came through, then the whole electoral process had to be cancelled, and the seat would have been vacant and there would have been re-election, because the elected candidate was a regularized employee.
Lordship.
These are the issues which arise.
These are
It is not that simple.
Lordship. True, Lordship. As your Lordship has rightly pointed out, she is here because she lost the elections.
Yes.
Had she won the elections, she wouldn't be here, my Lord. So, my Lord, with regard to the appearance of the respondent's name,
Now that she has lost the election, now she's thinking that I've lost both. I've lost the job as well as the election. Gone, both gone. No benefits under the job, election also gone.
Yes, Lordship, but before she resigned, she knew that she was ad hoc. She was very well aware that she was ad hoc. She knew the risk that she was taking, my Lord. It's not like she was in the dark throughout. She was aware of the endeavors made by the government, my Lord, since the year 2018. And the same has been reflected in the judgment by the learned single bench, Lordship. She was very much aware of the endeavors that
As an ad hoc employee, what will she get?
Pardon, my Lord?
As an ad hoc employee, nothing.
No, Lordship.
No benefits.
No benefits, Lordship. Because ad hoc remains ad hoc until regularized. Only when they regularize, they get pensionary benefits or they can take a voluntary retirement, my Lord. But here, she's not. So both options are not available to her. So she took the only road available for her to fulfill her personal desire of contesting the elections, my Lord. This is a personal decision, my Lord. It has nothing to do with the government's regularization, number one. Number two, handing out retirement benefits, Lordship. It has nothing to do with the government. Holding elections, yes. From the government, maybe, my Lord. But to stand for elections, nobody can force an individual to stand for elections, Lordship. That's a personal decision altogether. Why should the government suffer for the personal decision of one person, my Lord? Because, my Lord, as I stated before, I'll state again, she was not regularized. Resignation was the option for her. Now, my Lord, if she's going to get post-retirement benefits, this will open a floodgate to retrospectively also maybe, my Lord. We don't know, Lordship. Just because of one person, my Lord, we cannot go against the black and white of law. She had a choice. She was in education department, my Lord. It's not like she was not aware of the law. She knew, because this is her, before this memo of appeal, before the appeal before your honorable, this honorable court, my Lord, she had come for the second round of litigation. First was for disposal of her application. So she knew the ways of the court even before she tendered her resignation. She had sought advice, for sure, my Lord. She already knew what were the chances she was taking. It's only because she lost the election, that's why she came back to the court, Lordship.
Subject to what my brother thinks, we have to discuss the matter.
If I
You
may,
see, it is not that simple and not as directed by the learned single judge. Your service is gone. Now you have also lost the election. You have 2 years of service left.
4, my Lord.
4 years of
4 years.
service left. The court is also conscious of your 30 years service, etc. The best we can do is that we can ask the government to reconsider your letter of not to accept your letter of resignation and to reconsider your case for regularization afresh in view of the subsequent developments.
what the learned single judge is, in my humble submission, is essentially
Not as a matter of course, absolutely. You will speculate and then come and say that I am claiming this pension. If the government thinks that you have spent 30 years, you resigned for the purpose of contesting the election, you have lost, now you are getting nothing. So just in recognition of your 30 years service, if they reconsider you in the present factual situation, it is up to them.
If I may take your lordships through a few documents only, just to show my case, lordship, as to why the
Observation. They have already regularized it. They regularized it. Regularized.
if I may take your lordships through just a few documents, lordship.
Yes.
If lordship has seen my initial regulation, which I say that was the correct regulation in way back in 1998. Lordship, thereafter, in 2010, I was transferred, again by an order of the government. No indication that I was still an ad hoc employee. That transfer order, Lordship will find at page 43. Page 43. Page 43, Lordship. In the interest of public service, following employees of this directorate are transferred and posted place as indicated. I am at serial number 5, Lordship. Srimati UG Sangma, assistant teacher arts at so and so government school, new place of posting. So 2010, I was transferred from Ampati to Tura, Lordship. Again, here there is no indication that I am an ad hoc employee.
No, you come to page 105.
Lordship.
These letters referred to by the learned judge.
Yes, I'm taking a Lordships to that.
15.5, 2.7, 29.6, 10.8 and 4.10.
Lordship. Now thereafter, Lordship is pleased to come to page 45A of the paper book. These are the letters of 2045A. Lordship, this is a letter of 3rd April 2017 from the Director of School Education to the Special Education Officer. Lordship will note, no copy has been given to me of this letter.
What is the date of the letter?
3rd April 2017. All the letters are there, Lordship. 45A.
No, you mentioned the 4 letters cited by the learned judge.
Lordship, that is subsequently, Lordship. Kindly have page 46A. Is the...
Then 29.21, 10.2.22,
Lordship.
page 105, these letters.
Lordship, the first letter, 15/5/2017, Lordship will find at 46A. 15th May 2017. Lordship, this is a letter from the Joint Director of School Education and Literacy to the at Shillong to the Joint Director of School Education and Literacy, West Garhwil, Tura. I am no copy, internal communication, Lordship, not communicated to me ever. Now thereafter, Lordship will see the letter of 29/06/2017 at page 63. Page 63. Page 63, Lordship. Dated Tura, the 29th June 2017.
कितना बजे? You don't tell me that I have a bench with justice. What is that? Yeah. This must be told. Yes. बैठेंगे सबको बोलिए 1 बजे बैठेंगे. Yes, next.
Lordship, the next letter referred to by the learned single judge, page 63. I'm sorry, page 51. This is the page 51, Lordship. The printed page number, page 51. Printed page 51 on the top. Dated 29th June 2017. Lordships have it. This also, Lordship, is a letter from the Joint Director of at Tura to the Joint Director at Shillong. If I may only take your Lordships to the next page, point 3 of this said letter. It is also found that the service of Srimati Uttara Ji Sangma was regularized in grade A based on the order from the Additional Director of Public Instruction, White number so and so, dated 28/10/1996. The incumbent has completed satisfactory service as a teacher for almost 29 years, service up to date. In fact, since her regularization, her service has been extended for 21 years. This also, Lordship, internal communication, no copy given to me, page 51 and 52.
This is, what is the date of the letter?
29th June 2017.
Page?
Page 51 of the paper book.
All right.
Page 51. Now, thereafter, Lordship, the other letter referred by the Learned Single Judge, 10th August 2021. Lordship, at page 53 of the paper book. Again, Lordship, internal communication from the Under Secretary to the Director. No copy marked to me.
Take the post-it. Okay. Give a post-it. Post-it. Sticker. Yes.
Page 53, Lordship, is the letter of 10th August 2021. Also a letter from the Under Secretary to the Director. Completely internal, Lordship, no, not made aware to the petitioner. Thereafter, Lordship, the another letter, 4th October 2021, at the next page, page 54. Type copy at 54A, Lordship. Again, this is a internal communication from the Joint Director to the Deputy Director. No copy marked to me, never informed to me. And thereafter, at page 55, Lordship will see yet another letter of 20th September 2021. Again, internal letter, Lordship. Page 55, 20th September 2021, from the Deputy Director of School Education to the Joint Director. No mention about me, Lordship. And finally, the letter referred to by the Learned Single Judge, that is of 10th February 2022, at page 56. Again, Lordship, from the Deputy Secretary to the Government of Meghalaya to the Director of School Education. Copy to the Director. So these letters were never made aware to me. Thereafter, what happened, Lordship? On 1st November 2022, I submitted an application for VRS. That my application for VRS, Lordship may find at page 61. Page 61, Lordship, is my application for VRS, submitted on 1st September 2022. I may read, Lordship. With reference to the subject cited above, I have the honor to state that my date of joining ad hoc sanction post was on 1/9/1988, and my date of regularization as per government order was on 1/9/1996. As per Government Admissible Rules 38A of the Meghalaya Civil Service Pension 4th Amendment Rules 1998, I have completed 34 years of continuous service prior to my date of joining, and as per my date of regulation, have completed 26 years of service to the government. May I therefore request you to release from my service on personal matters. Rule 38A gives a timeline of 3 months, Lordship, for them to reject it. Otherwise, it is deemed to be accepted. 1st November. Now, they sat over it, Lordship. They sat over it. And after making multiple representations, I had to approach this Honorable Court for them to take a call on my application. That judgment, Lordship will find at page 122. I came with a limited prayer, Lordship, to dispose of my VRS and subsequent representations. That was decided by this Honorable Court, page 122. Lordship, the date of the decision is important, Lordship, in my humble submission, page 122. Date of decision, 2nd February 2023. And if I may point out, the last date for filing nomination for the election was on 3rd. So on 2nd February, the government came up with a letter of 31st January 2023 saying that my VRS could not be accepted because I was not yet regularized. That writ petition became infructuous and it was closed, Lordship. On the same day, on 2nd, considering the urgency that election...
Where is that letter? A letter dated?
31/1/2023, Lordship. That letter is at page 124. 124. Now, this was when I first came to know, Lordship, about this issue of regularization not being by the competent authority. If Lordship is pleased to see page 124, dated 31st January 2023. With reference to the subject cited above, I am to inform you that the signatories of the letter order number so-and-so dated 28/10/1996 and letter order memo number so-and-so dated 7th September 1998 has not been delegated with power to issue such letter of regularization.
Page?
Page 124. 124. Next page. 31st.
Thereafter you resigned.
This happened. Then thereafter, I have resigned at page 125.
All right. So, Madam, you wish to add anything?
My lord, just to the extent that the documents relied upon by the learned single bench were matters brought on board by the respondent when they had filed the writ petition, Lordship. So their claim to their being unaware is far-fetched, Lordship, because even on perusal of their affidavit, they do not state anything that they were made aware, and it was only after application of any of maybe an RTI or something that they got these documents. It's silent, Lordship, the affidavit. So on the face of the affidavit, Lordship, it is taken that they were very well much aware of the correspondence, and the correspondence copies, they kept on stating that copies were not made to them. Lordship, the correspondence between the government authorities was for clarification and justification of the letters of the regularization of 96.
Yes.
So it's mainly for justification, which the respondent should not be in a position to receive any copy of, Lordship. But on the face of the judgment by the learned trial court, Lordship, the petitioner, the respondent were well aware of the efforts and the endeavors taken by the state government.
All right.
Only 2 minutes of your
No,
lordship.
no, no, not reply to reply.
No, I'm not replying. I'm just saying what the learned judge has held with regard to this.
We have that is not required in reply.
No, sir.
Any law point is the reply she has given.
No, that I
You wish to file notes, you file notes.
may file a small written synopsis. If
My lord,
Would you like to file notes?
if,
Written notes?
if directed, my lord, we will file lordship.
No, it is up to you.
Lordship. Then we'll file
Alright.
lordship.
Hearing concluded, CAV, stop, CAV.
Much obliged, lordship.
published.
Advocate of record for either party is at liberty to file written submissions. With the court master attached to this court by 24th February.
Lordship.
Published.
Item 1.
On the last date, my lords had asked for filing of a short paper book that has been filed with a copy served to the respondents.
Proceed.
My lord. Lordship comes to the paper book at page 59. This is the judgment in appeal, my lord. Decision of 5/12/2022. The opening few paragraphs of the judgment, my lord, itself gives a whole background of this litigation and other connected litigations, my lord. This is a litigation relating to pay parity within a particular trade called the clerks in Assam Rifle, my lord. Para 1, if my lord, we proceed, my lord, the judgment takes on record that in the year 2010 earlier, my lord, a writ petition was filed by a group of persons serving as clerks in the Assam Rifle. They were seeking parity in pay with other central paramilitary organizations. And at page 60, my lord, is the operative portion quoted. Now, where we stand is that, my lord, we were not a party in the original writ petition of 2010. But at page 60, para 14 is the effective portion of the judgment earlier rendered by this court. It says, my lord, that in the result, this writ petition stands disposed of with a direction to the respondent number 2, Director General, Assam Rifles, to take up the matter again with respondent number 1, Secretary, Government of India, to bring parity in respect of rank and structure and pay of the Assam Rifles clerical cadre at par with other CPOs by introducing rank of Assistant Sub-Inspector Warrant Officer at entry grade with effect from 1/186 in the scale of pay of rupees so and so with effect from 1/1/1996 or any other date as the authority may deem it fit proper with consequential service benefits in the light of Government of India Ministry of Finance resolution dated 29/1997 communicated through letter dated 10/10/1997. The whole exercise should be completed within a period of 6 months from the date of receipt of the certified copy of the judgment, my lord. What I in this particular para, my lord, would like to emphasize on is that the learned court was, my lord, very specific that it did not just speak about the petitioners, it spoke about introducing this particular rank to the entire clerical trade, my lord. Now, writ appeal thereafter, my lord, was filed, as can be seen from para 2 of the judgment. Writ appeal 40 of 2012. The judgment was, my lord, not interfered with, and some modifications were made only. Against that, my lord, there was an SLP. The SLP, my lord, upheld the findings of the learned single judge. Now, with emphasis, my lord, on the fact that the exercise was actually to be carried out for the entire clerical trade, I would like to say that this particular judgment rendered in 2012 as upheld by the Apex Court is a judgment in rem. It covers the entire clerical trade, my lord. That obviously, my lord, seems to be the understanding of the ministry also. When the ministry considered this matter, my lord, I would take your lordship ahead in the paper book again. If we come to, my lord, page 31. The matter was put up, my lord, before the Ministry of Home Affairs in consultation with the Ministry of Finance. At para 2, my lord, would see at page 31. It says that the subject has been examined in a ministry in consultation with Ministry of Finance, Department of Expenditure, and it has been agreed to implement the judgment dated 23/8/2012 of the Honorable High Court of Meghalaya, Shillong Bench in WBC 277 of 2010, upheld by the Supreme Court's order dated 17/11/2015, both in the case of the petitioners as well as other similarly placed employees. So, though we were not petitioners, my lord, when we came back to the learned single judge, that the implementation now is to be not only in respect of those petitioners, it has to be in respect of everybody, my lord. When we came back in 2019, my lord, the learned single judge, my lord, finally came to a finding that we were fence sitters, and since we did not join the litigation in 2010, the same benefit cannot be extended to us, my lord. If I read page 70, my lord, para 27, the learned single judge gives a finding that the judgment dated 23/8/2012 is a judgment in personam, he says. Whereas, my lord, from the language of the judgment, which says that it is to be it is an exercise for the entire clerical trade, and the way the ministry had directed that it should not be confined only to the petitioners, and benefits should be extended to everybody, my lord. The very language of it, my lord, is a judgment in rem.
Come to para 25.
My lord. Again, as far as the case of 87 petitioners are concerned, the learned CGS's failure submitted that it was an oversight or inadvertence that they have been allowed to participate in WBC number 277 of 2010, and for this the respondent Assam Rifle had to pay a price of extending the benefit of the said order dated 23/8/2012. This benefit, however, is considered in the opinion to certainly not extend to the petitioners herein, firstly, as they have not joined issues with their colleagues on the first round of litigation, and secondly, there is no question of seeking parity of any consideration of the fact that they are enrolled under the relevant recruitment rules of 2002, and these rules have not been challenged by the petitioners.
Forget the first.
My lord.
Let us accept that it's an order in rem.
My lord.
They have been equality demands, you should also be.
My lord.
But are you in the same position?
My lord, we are, my lord, in a
Being
sense.
Under the recruitment rules of 2002.
My lord, what had happened in Assam Rifles is that earlier, my lord, the persons who had come before this court, they were called, before Fifth Pay Commission, they were called lance-like writers. These lance-like writers, my lord, the name was changed and they were called Havaldars, Havaldar clerks, thereafter, my lord, from 2002 onwards. In 2002, when this recruitment rule came, my lord, everybody, my lord, was at that Havaldar rank, because that became the initial rank. The finding of the court is that the initial rank should be warrant officer, ASI, in this and this pay scale in terms of the Fifth Pay Commission's recommendation. So when that judgment was implemented, my lord, it was implemented by introducing this post without there being, of course, any modification in the recruitment rules. So it was apparently introduced as an ex-cadre post, or that particular benefit was introduced in respect of Assam Rifles by giving the benefit to the petitioners therein, my lord. The question,
you are in which post?
my lord, we are older clerks.
You are in Assam Rifles.
We are in Assam.
What is your post?
My lord, we are Havaldar clerk.
You joined in 2000 under the 2002 rules.
My lord, after 2000.
Havildar,
Havaldar.
clerk.
Clerk, my lord.
Now, what is the redesignation you want?
My lord, it is a ESI, warrant officer, my lord.
Of the central services.
Central services, my lord. Because that was the recommendation of the pay commission and that was implemented in respect of other persons, my lord, who were also serving in a post equivalent to Havaldar, because earlier they were called writers.
You had joined under which rules? 2000?
2, my lord.
You know what is the full nomenclature?
Of the rules, my lord.
Yes. Paragraph 25?
25, my lord. Recruitment rule. My lord, it is called Assam Rifles Group C Recruitment Amendment Rules of 2002.
Group C amendment?
Rules 2002. Assam Rifles Group C Recruitment Amendment Rules 2002.
And in which post they joined? Those 87 petitioners?
My lord,
Those
not 80,
1000 so
1030 something, my lord. They were Lance-Naik writers. Earlier, Havaldar used to be, before 5th Commission, my lord, Havaldar used to be called Lance-Naik writers, my lord. Then to bring in uniform names across different parliamentary forces, my lord, the name Lance-Naik writer was changed to Havaldar. That history, my lord, if we read the 2012 judgment, my lord.
Lance-Naik writer.
Lance-Naik writer, within bracket writer, W-R-I-T-E-R. Because they used to do the writings of probably, my lord.
This was under which rule?
My lord, prior to 2002 for clerks, my lord, there was no rules, my lord. They were recruited as under the GD rules only. Specifically, there was no rules, my lord.
Under?
Before 2002, my lord, there was no specific rule of recruitment for Lance-Naik writer clerks. They were recruited as other Lance-Naiks, my lord, in the force. Under
administrative powers?
My lord, under...
There was no rule?
No, there was a rule of appointing, my lord, not the specific trade of clerk, but then the recruitment rule was for recruitment of entire force in the rank of Lance-Naiks.
General rules?
General rules, my lord. So everybody came under the Lance-Naik, my lord, category. Because that was the initial post in most of the trades earlier, my lord, prior to 5th Pay Commission.
You are still Havildar clerk?
We still have that.
And the earlier writ petitioners, so what is
They were Lance-Naik writers who then, my lord, because of the change of name became Havaldar. But then because of implementation of the judgment, they got a higher pay. And the rank is not the issue, my lord, the pay is the issue. Because now we are also doing the same duty. The other batch who came before your lordship earlier, they are enjoying a higher pay and we are enjoying a lesser pay. While doing the same duty of clerk, my lord.
No, they have been redesignated as Havaldar.
They have been redesignated as warrant officer.
What is the difference in pay between you and warrant officer?
My lord, 4,000. It's 800 rupees is the difference. In 5th Pay Commission, it was, my lord, we were in 3,200. They were in 4,000.
So you want revision of pay to this
4,000, my lord. So that there is a parity between them and us. We are doing the same job, my lord.
But the learned judge says that this was not within the scope of a challenge in the writ petition.
My lord, the question of challenge is
between the
my lord, this
present
post,
rules.
the post of warrant officer did not even exist earlier, and even today it does not exist, my lord, in the recruitment rules. In Assam Rifles, my lord, mostly this has, after the Fifth Pay Commission when it was just implemented, my lord, this rank of warrant officer was introduced without amendment of the recruitment rules, and therefore there are a lot of litigations, my lord, in this court on the same issue.
So you are doing the same work as a warrant officer?
My lord, we are doing the same work as a warrant officer.
How do we get that? You are doing the same work under the 2000?
Because, my lord, because there is no recruitment rule of warrant officer, there is no post of warrant officer in the recruitment rules. Only the scale was changed in recommendation of the Fifth Pay Commission in respect of those persons who were given the benefit. Otherwise, my lord, we are all clerks, my lord.
No, but their designation after the round of litigation is warrant officer now
Warrant officer.
in Assam Rifles.
My lord, there is no different charter of duties for them, man. In fact, after the 2012 judgment was implemented, another batch of petitioners were also before your lordship. In that matter also 197 persons, my lord, ultimately the Supreme Court allowed. And these are also persons who have joined after 2012. That has been allowed, my lord, and the order, my lord, would see at if your lordship comes to the paper book at page 50, Ajay Kumar and others, my lord, these were a batch of 197 persons. Page 50 says the matter pertains to the respondents who are working in the Assam Rifles under the impugned judgment. The High Court has granted relief towards seniority placement and related pay benefits vis-a-vis their colleagues in the same organization. Having considered the basis of the impugned judgment and also noticing the huge delay of 231 days in filing of the special leave petition, we are disinclined to either condone the delay or entertain the special leave petition. Both are dismissed. Thereafter, it is again implemented, my lord, at page 52 in respect of this 197 persons only. We 635 odd people, my lord, the only persons who are left out from this benefit now.
How much more time you will take?
My lord, if the background of the matter is to be gone into
background is understood. The more you amplify, the background will become larger, but it is
My
not. It is not very large at all.
because I don't want to reopen what the Fifth Pay Commission had recommended. This matters had traveled to the Apex Court twice and SLPs got dismissed. So whatever the learned single just
With the
said,
central services, according to the Pay Commission,
my lord,
you filed a writ here, appeal SLP to the Supreme Court. The parity was ordered.
order.
Out of 1,600 or 1,700 odd, 1,500 plus were granted the benefit, 98 were left out. They preferred contempt, etc., to be,
My lord.
and that order was also complied with.
Complied with.
Thereafter, you filed this writ saying that similarly situated, it is dismissed on two grounds: delay, that you were sitting on the fence while
Others were litigating, my lord.
waiting for the result of their litigation, and number two, your recruitment terms are different.
My lord.
That's all.
That's all, my lord.
2020 day after 2020.
But then what I had, my lord, pointed out in my synopsis and in my thrust of my argument is that this, no doubt in 2002 a recruitment rule had come. We are not adverse to the recruitment rule. But the way the matter has been implemented is that this post is a non-existent post. Till now, it has not come. Warrant officer has not come in the recruitment rules.
So you want the post to be redesignated as warrant officer
My lord.
and to be paid in their scale.
Their scale, because my colleagues are drawing, my lord, just because they,
Not colleague, but you are doing the same type of work.
my lord,
And you have the kind of same cause of action as the others.
my lord, my lord. That is roughly the sum and substance of my case. And I would like to emphasize that other persons also who had joined after 2002 in the same recruitment rules, this 197 person, my lord, in Ajay Kumar's case, they have been also extended the benefit. We were the only one left out because we were caught, my lord, as fence sitters, my lord.
No, those 98 persons who joined
My lord.
were also under the 2002 rules.
My lord. Initially, what happened? The ministry said, my lord, that you implement it in respect of everybody. Then, while implementing, the Assam Rifles thereafter, in a second order passed by them without approval of the ministry, they said that we will extend it only to the persons who had joined up to 2002. Then the contempt comes.
That might be considered because I may or may not be a fence sitter. I might be I might be a negligent person or someone who is not at all conscious of my rights.
My lord.
I do nothing. But if the government is redesignating others, and I am similarly situated,
my lord,
they also have an obligation,
my lord,
irrespective of whether I have approached the court or not.
my lord, my lord. That is
they have an independent obligation.
My lord, my lord. In fact, that is the tenor of the sanction and approval of the ministry initially. That is why I read, my lord, page 31. The ministry, in consultation with the finance ministry, says that you implement in respect of the petitioners and also others, my lord. But then the Assam Rifles, thereafter, they restrict it.
Suppose the university is giving grace marks to 100 students who have got 40 marks.
My lord.
Plus 2, plus 2, plus 2. Say 20 have not approached the court at all. That doesn't mean they will not get. If the others are getting, they have an obligation to consider the others.
My lord,
The
precisely, that is my case, my lord.
That we will consider separately. But the second point is first, that you are under the 2002 rules, which learned single judge has said that is different from what was considered in the cases which went to the Supreme Court.
My lord.
You will keep it this Friday for further hearing?
Friday is...
Don't take much more time, otherwise we will...
My lord, I understand. Only on that point, lordship, then I will...
21st is 21st is already. 21st.
21st, my lord. 21st holiday.
Day after tomorrow we will keep it. We can finish the matter. 20th.
20th, my lord. Okay.
Learned counsel for the appellant. Commences arguments and the appeal, but does not conclude the same. Lists this appeal for further hearing on 2-0 at 12:45 p.m. or at 12:45 p.m. Earlier, I just put down. It will be a fixed time.